This is Phil Hardy, Director of the Center for Civic Leadership at Benedictine University. This is the first of what we're calling the CCL podcast, and we're joined today on this rainy, extremely rainy Tuesday in November by former U.S. Solicitor General Paul Clement. Mr. Clement is here to talk about his experiences as an attorney working on cases before the United States Supreme Court. He is now a partner with Bancroft PLLC in Washington, D.C., and is a lecturer at Georgetown University. My introduction does not do justice to his extensive resume and experiences, but Paul Clement, thanks so much for stopping by and taking some time to visit with me today.
Oh, it's great to be here. It's great to be here. Wish the weather was a little better, but what can you do?
And how was your boat ride in?
Yeah, it was just fine. Fine.
Good. So we were chatting before we turned the recorder on, and we both kind of have connections to the Wisconsin area. I wonder if you would like to start by just telling me about your Cedarburg, Wisconsin roots and what that did for your life leading up to your undergraduate experience at Georgetown.
Sure. No, I grew up in Cedarburg, Wisconsin. I'm a product of the Cedarburg Public Schools, and I'll tell you, I'm a firm believer that Cedarburg, Wisconsin is a great place to grow up. It's just a tremendous community. It was just north of Milwaukee, a little bit of suburbs, a little bit of some folks who were still farming. So it's just a great kind of cross-section of individuals, and I think that it was just a great way to get to learn how you deal with all sorts of different people, and it was really a great education, as you tend to get in the Wisconsin public schools. I think there's a really strong tradition of that within the state, and really prepared me very well to go to Georgetown. I mean, it wasn't the usual route from the Cedarburg Public Schools.
Mm-hmm.
They were more set up to send you to Madison or to Whitewater.
Right.
But I was very interested in international relations. And Georgetown had a great program for it, and I got there, and at first I was a little overwhelmed, but I think in the end I felt like I had just as good a education to prepare me for Georgetown and things beyond than some of the my classmates who were going to fancy East Coast finishing schools or whatever they call them.
So is it just Cedarburg Public High School? Is that the name of the school?
Cedarburg Public High School. Yeah, there was no need to add a modifier because there's
Great.
Only one.
Terrific.
And
do you remember about what size your graduating class was? Was it small?
It was
medium?
about 300.
Okay,
about 300. So
medium to large, I would say. Guessing.
Exactly.
Yeah, good.
Exactly.
And at what point in your life did you know that? So you go to Georgetown, which I assume was a fairly, as you mentioned, kind of a fairly rare jump from a place like Cedarburg to go to Georgetown, and you were interested in international relations. At what point did the bug get you about thinking about law school? Was it early? Was it before undergraduate, or when did you think you might want to be a lawyer?
Yeah, it was actually pretty early because I'm the youngest of four children, and my oldest brother who's 12 years older than I am, went to law school before I did. So he must have gone to law school when I was like 9 or 10 years old. So the idea of going to law school, at least as a possibility, was something that I was aware of pretty early in my life,
mm-hmm.
and was sort of interested in as a possibility. And then when I got to Georgetown, I really kind of came to a fork in the road because I'd studied international relations, but particularly international economics. And then I was able to go to England on a scholarship for a year and study more economics. And I really came to a point where I had to kind of choose between going down the sort of PhD in economics route or going to law school.
Mm-hmm.
And it wasn't an easy choice, but I obviously decided to go to law school at that point, and have really certainly never looked back. I mean, I thought that probably have a perfectly interesting life if I'd gone the other way, but it's one of the great things about lives is you reach one of those points, and you gotta zig or you gotta zag.
I agree.
Went to law school at that point.
And what advice would you have for an undergraduate? Was the LSAT prep probably similar to what someone goes through now? Do you remember any sort of anxiety or concerns about how am I going to do on the entrance exams, or
I think
what you would say to someone who's thinking about becoming an attorney?
Yeah, on the LSAT, my sense of it is that things have changed a bit in terms of just the intensity of the preparation process. I mean, I took a prep course and the like, but just people seem like they're much more focused on those exams than even they were when I was taking them. So they're obviously something that the law schools take into account, so you can't ignore them. But in some ways, I almost think there's too much focus on those kind of tests. And with my oldest son, we're going through the same thing now for colleges, and that is way more intense than it was when I was a kid. And I'm not sure that's a change for the better. In terms of law school, my only advice to people would be, don't go to law school unless you want to be a lawyer. I think that's with the legal economy being not quite as lucrative as it has been in some past years, I think more people are looking really hard at that decision. When I was in law school, I had a sense that some of my classmates were there just as kind of a default option.
Right.
Wasn't sure what else to do. I'll go to law school. And I think now that people aren't doing that because there's no sense incurring the debts associated with going to law school unless you really want to be a lawyer. But I think that's a good thing, because if I think back at my classmates, the ones that were happiest in law school and the ones who are probably, as far as I can tell, most satisfied with their legal career are the ones who really wanted to be a lawyer, not the ones who kind of weren't sure what to do and probably would rather be running a restaurant or something. So if you can get an insight into what lawyers really do, and then it seems like something that stokes your passion, great. But if law school and being a lawyer doesn't stoke your passion, you should probably find something else that does.
So I'll leap forward a little bit. So we're talking about connections from Cedarburg, Wisconsin to Georgetown, then to Harvard for law school.
Right.
You were an editor for at least a portion of the Harvard Law Review. And obviously when someone looks at your CV or your resume, I'm sure one of the things that jumps out to them is the fact that you clerked for Antonin Scalia on the Supreme Court. Any stories you'd like to share about that? Is there sort of a legendary story about Justice Scalia that you can share, or more broadly about what your experience was like working as a clerk?
Well, what I can say about the opportunity to clerk for Justice Scalia, which is an opportunity any young lawyer would love to have, is that it really was a tremendous experience. But part of what made it almost uniquely a terrific experience is that Justice Scalia's chambers was really a chambers where everything was done orally. You interacted with the justice directly. He was not a justice who was looking for a bunch of long memos about the cases. The most he ever asked for us on a Supreme Court case was a one-page memo just laying out the bare facts of the case and one or two salient issues in the case. But everything else was really done orally. You'd interact with the justice. He would tell you were wrong. You'd try to push back. And what a great experience for a young lawyer, because for those who aren't familiar with Justice Scalia, he has quite a reputation for being an intimidating questioner of lawyers
nonsense. He's famous for saying nonsense or right.
Exactly. And and if he thinks your argument is nonsense, he'll tell you so. And he's just he's really, in a way, he's really changed the way Supreme Court arguments take place, because when he went on the Supreme Court in about 1986, he started asking a lot more questions than his more senior colleagues. And soon enough, his senior colleagues are like, well, I'm not letting this new guy ask all the questions. I'm going to ask some questions as well. And so he's really kind of transformed the nature of Supreme Court argument. And it's really, again, it's sort of famous for being this, great questioner of advocates. So to be fresh out of law school and have the opportunity to interact with him where he's asking you, very difficult questions, but it's in the privacy of the judicial chambers, so if you have a really lousy answer, nobody's going to know about it, and you can interact with them and over time develop better responses to his inquiries and mix it up with him once in a while on some legal issues. What a heady experience, but also an experience I think really prepares you for the next steps. There aren't that many experiences in the law that are more intimidating than disputing a legal point with Justice Scalia.
Have you looked back on your time as a clerk, someone teaching, for example, an introductory law and politics class, which we offer here, for instance, and you talk about the role of clerks as the gatekeepers in really filtering through an enormous number of requests that are, most of them are not recognized by the court and given a review, and standard teaching on that is that the clerks play an important role in sort of filtering through which ones as the gatekeepers. And I wonder if you look back and think, wow, what a responsibility. Is that true? And what was your experience like? And if I could also add, about how many other clerks did you work with just for Scalia?
Sure. Well, typically at that point, and I think it's still true to this day, each of the justices has 4 law clerks for a year.
Okay.
So you got 36 law clerks basically up at the court at any one time. Occasionally, usually the retired justices will have 1 law clerk each. So you might have, 37, 38 law clerks up there at any one time. What they teach in the class is true. The law clerks really do have an outsized role in what the Supreme Court lawyers call the certiorari process, or the cert process, and that's really the process of the Supreme Court deciding which cases that it's going to hear each year. A lot of Court of Appeals, like the Seventh Circuit Court of Appeals here in Chicago, they have what's essentially mandatory jurisdiction. So if you don't like what the federal trial court judge has decided, you have a right to appeal to the Seventh Circuit. And in the state court system, it's the same. Usually, if you lose in the trial court, you have a right to take it up to the next level. But it doesn't work that way with the Supreme Court. You have a right to ask them
Correct.
to hear your case on the merits, but most often they say no. And so, the rough numbers are that in a typical year, the Supreme Court will have about 10,000 petitions asking the court to review a case, and the court will only take about 75. So you're talking about a winnowing process that winnows out over 99% of the petitions. And because of the volume of those requests, you really do have the law clerks playing a really central role. When it comes to oral argument in the Supreme Court, when it comes to the merits cases, the 75 cases that the court ultimately hears, the old adage in Washington, D.C. is that the Supreme Court justices are the last people in Washington who do their own work. And as to the merits cases, that's really true. But with the volume of cases you have in the certiorari process, there's ultimately the decisions as to which cases are going to be decided by the court is made by the justices. But this winnowing process is one where the clerks play a central role.
Interesting.
I always tell there's the justices choose from cases that get on what's called the discuss list, and that just means that a petition is sufficiently interesting to merit discussion among the justices themselves at their conference. And I always tell my clients that you have whatever your other chances about getting cert, you have a 0% chance of getting your petition granted if it's not on the discuss list. And the law clerks really do play a pretty central role in recommending to the justices which cases go on that discuss list. From there, it's the justices that really take over. But the law clerks play a big role in that first step.
So, moving forward again, remarkable experience in your life, remarkable experiences as an attorney, and then you're nominated to be Solicitor General of the United States under George W. Bush. Can you tell me, from a behind-the-scenes perspective, do you get a letter in the mail? Are there feelers out? Is the Attorney General the person that contacts you, or does the President call you and say, Paul Clement, I'd like you to be my Solicitor General?
Well, I'll tell you, in my case, the process was not at all dramatic. There was no sort of call from either from the blue or based on a lot of staging or anything like that. Is that because you were
acting?
But that's because I was acting, and before then, Principal Deputy Solicitor General. The way that, having watched the Office of the Solicitor General, but I think this is true of a lot of government posts, at the beginning of an administration, and obviously with these presidential elections next year, no matter who wins, it will be a new administration coming in. At the beginning of the administration, there's a lot of jockeying for position, and people who've worked on the campaign feel like they deserve certain jobs. People who know the president-elect from wherever state they came from think they have a sort of an in to get the jobs. There's a lot of jockeying. Once the administration gets going, then there are a lot of jobs where if the Solicitor General or the Assistant Attorney General for the Civil Division at the Justice Department, if somebody in that position leaves after 3, 4, 5 years, then a lot of times serious consideration will be given to promoting the person who's been their deputy, especially if it's somebody who has developed a good reputation and somebody who people think would do a good job. And that's not to say that there aren't some other people who say, oh, so and so's leaving. Yeah, let me lobby this in. Let me call this contact. Let me try to do what I can. But I think when you have these kind of mid-administration switches for positions that are sort of sub-cabinet, it's a little different. If the Attorney General leaves, then there's usually a big process and a lot of speculation about that. But at sort of the Solicitor General level, the Assistant Attorney General level, there is a lot of consideration given to the possibility of promoting the person who's been there before. Mm-hmm. And since that was my case, I almost felt like, I mean, best thing I could do is to keep my nose down and keep working. And when they told me to vacate the office, I would, but and they never did. So
there wasn't a moment when you went home to your wife and said, "Dear, you're not going to believe it. I've been nominated."
Yeah,
to be
there was certainly a point where it became, it went from becoming sort of what I assumed was going to happen to, actually being notified that, the papers had been sent with the presidential seal up to the Senate and all that kind of exciting stuff. But it was really a pretty gradual process, and like I said, it was almost a process of it becoming a fait accompli.
And how much contact did you have during the 3 or so years that you were Solicitor General with the President? Is that a rare case? I mean, is it primarily you're dealing with the Attorney General, or were there moments when you're consulting with the President Bush, in this case, about specific cases before the court?
Yeah, in the Bush administration, it was a relatively rare instance in which you would interact with the president directly. It really wasn't even all that frequent that you would interact with the White House counsel's office, but to the extent there was something that the president needed to be aware of, the principal point of contact for that would be the White House counsel's office. You would also interact with obviously the Attorney General's office because the Attorney General's just down the hall. So there's a much more sort of constant almost interaction with the Attorney General and the Attorney General's office. There's sort of intermittent interaction with the White House counsel's office, and then there's quite rare interaction with the president personally. What's interesting is if you there've been a couple of symposiums that have been put together over the year where you get like 6 or 7 different solicitors general who work in different administrations, both in terms of different parties, but also just different presidents. And what's interesting about those is there's really a fair degree of variation. The people who worked in the Clinton administration, you have Bill Clinton, this former constitutional law professor who was, kind of famous for wanting to sort of, get into the details in a way that, maybe, made his meetings run over and, made him schedule challenged. But, my sense from talking to people who had the job in the Clinton administration is there was much more sort of frequent interaction directly with the president. In the Bush 43 administration, you had a president who was not a lawyer. He certainly respected lawyers, but he dealt with the lawyers a little more the way I think an executive officer of a company or a governor would interact with his lawyers, where he'd take their counsel, but he wasn't going to sort of debate the details with them the way that I think President Clinton might have been tempted to do. And then the other thing that I think makes a difference is sometimes you had this with Walter Dellinger, who was the acting Solicitor General for President Clinton. You have that with the current Solicitor General, Don Verrilli. Sometimes you have a Solicitor General who previously worked in the White House. Mm-hmm. And then in that situation, you probably, I can't speak to the current situation, but I think with respect to, Walter's talked about this publicly, and I think, in his situation, he had a lot of interaction with President Clinton, but that's in part because he was used to having interaction with him when he briefly worked in the White House or when he worked in the Office of Legal Counsel, which typically has more interaction with the president directly. And so if you're in a pattern where that's already happening, it's probably more natural that it continues. Whereas, if you have a situation like my situation or my predecessor, Ted Olson's situation, where, neither of us had worked in the White House, then I think it's, you tend to work kind of more through the ordinary channels. Certainly something to be said for both. Maybe it's natural to be more comfortable with the situation that that I operated in. But I think there's something to be said for having the Justice Department handle these cases, make sure that the White House doesn't get blindsided by a case that has political implications, but not necessarily having the White House calling over on a too frequent basis. One of the things about the Solicitor General position that's a little bit, it's certainly interesting and is a little bit hard to understand, is there is this tradition of relative independence from kind of the political forces at the White House. The reason I say it's kind of difficult to understand is if you look at an org chart, it's pretty clear. I mean, the Solicitor General works for the Attorney General, works for the President. Boom, it's a pretty much straight line organizational chart. So it's really more a matter of tradition than it is of anything that you would glean from an organizational chart. But the tradition is to have there to be a sort of a degree of independence, just kind of like say practical independence, which I think is reflects the idea that since the Solicitor General is constantly interacting with the Supreme Court, and I think the office wants to sort of project that it's presenting the sort of considered position of the executive branch and its kind of long-term interest, not necessarily presenting the short-term political interest of the occupant of the White House at any one time. Now, that's not to say that if you look at the office and the positions it takes in Republican administrations compared to Democratic administrations, there certainly are differences. But I think it's probably institutionally a good thing that those tend to be sort of differences of degree, not just like whoa, we just had an election, now all our positions are going to change.
So what caught my attention about you was, I believe, a Washington Post article about your role in arguing as a private attorney in the Defense of Marriage Act case. I think the Post did a profile of you as sort of one of the last remaining really legal titans arguing the position that you did. And I think the contrast, even in the article, mentioned Ted Olson's role on the other side. And I wonder if you could share some thoughts about what motivates you in these types of cases and what the experience was like in that particular case, or other, because there's a pretty long list of some very serious cases you were involved in, either as Solicitor General or as a private attorney, and what that impact has been on your life.
Sure. No, look, one of the great things about being, a lawyer, generally speaking, but particularly an appellate lawyer, is, there's a lot of jobs in government where if you talk to people who, had this or that government position, when they have to, transition out either for financial reasons or there was an election and, their party's out of power, it's almost like they're just dying to get back into government, because the sort of the delta between how interested they are in doing what they did in the government and how interested they are in what they get to do outside of government is a significant difference. And it kind of makes sense. I mean, it must be amazing to be Secretary of Defense, but if you try to direct troop movements and outside of government, I think it's called treason. So there really is a big sort of change between one and the other. The great thing about what I've been able to do since I've left government is every major Supreme Court case has two sides to it. I mean, you can't, it's the adversary system, and in many of the major cases that get to the Supreme Court, you'll have the Solicitor General representing the United States government on one side of the case, but then there'll be a lawyer in private practice who's representing the other side of the case against the federal government. And that's almost unique in that you can sort of feel like as a lawyer who gets the opportunity to argue cases in the Supreme Court or other major pieces of litigation, it's as if your role in the private sector is not that different from your role in the public sector, but also I think ultimately just as important to the justice system, because the lawyers in our system, we don't get to decide the outcomes of the case. And the idea behind the system, though, is that the Supreme Court and the courts of appeals, they decide their cases based on the adversarial presentations of the party, and both parties are every bit as important. So I just feel I've been very fortunate to be able to get involved in some of these major issues, and certainly you win some, you lose some, but I think part of the reason for a lawyer it's a little bit easier to kind of you don't celebrate too much when you win one, you don't get too down when you lose one, because you also feel that like you've played your role in the system. It's as much as I'd like to sort of, be able to just flip a switch that makes the Supreme Court rule in my client's favor. In reality, you make your argument, you try to make the best argument that you can, and then they make the decision. And, as I say, I just feel, very, very privileged that I've been able to be involved in these really, kind of interesting, important issues that affect lots of, sometimes they affect lots of people. Sometimes, it's a little harder to understand where the impact is going to be, but they're really questions about, the structure of our government. I'm arguing a case in a couple of weeks in the Supreme Court about whether one state can be sued in the state courts of another state without its consent. Now that's not a pocketbook issue that people are going to think, wow, I'm clearly rooting for one or the other. But on the other hand, that's actually a really important issue in the overall structure of our government. We have this system of federalism. A state government can't be sued in its own courts without its consent. The 11th Amendment to the Constitution specifically addresses when it can be sued in the federal courts. And here's this, somewhat unanswered question about, in my case, it happens to be whether California can get sued in the state courts of Nevada. But it's not only an important question, but it really gets to the heart of kind of our constitutional government. And the chance to, get involved in cases like that is something that, certainly, I don't have any trouble in the morning, when I get up being interested in going to work. It's a great way to practice law.
Beyond the legal and procedural items that you've discussed, do you look more broadly at our political system and worry about polarization and the lack of friendly discourse or of agreeing to disagree in a way that's civil? It seems like that's something that's been around since at least the mid-1990s. And running a center that's nonpartisan and that welcomes a variety of people, I can't tell you the number of times we get, when you choose for one side, the other side's upset and vice versa. And I wonder if you look at that and have any comments about the condition of our democracy and party polarization, the things that get brought up among people who are concerned about what's going on.
Well, I definitely think there are reasons to be concerned. I mean, I think, on the one hand, this isn't a new problem. I mean, you look historically and you have members of Congress being caned in the, on the floor of the Senate or the House, I forget which. So it's not like, it's a completely distinct problem.
We didn't just have the Federalist Papers.
Yeah, exactly. On the other hand, I think a lot of people have a sense that we've entered sort of a different cycle, mm-hmm. And I'm not, I guess I'm too busy arguing these cases to be able to sort of really study. I have my sense that part of it's the technology, part of it is you now have computers that allow you to sort of assign voters in voting districts in ways that I think may sort of may contribute to the fact that our political bodies are very divided and all of that, and they're kind of almost like you used to have pretty broad swings in election. I mean, you sort of think about President Reagan, carrying every state but Massachusetts or every state but Minnesota, I think, in his 2 elections, and you sort of it seems almost inconceivable right now that any candidate could carry that kind of all but one state kind of thing in a way that would suggest there's like a real mandate across the country. So you do worry about it. I guess the one thing that maybe gives me kind of an interesting perspective on it is I do think the Supreme Court bar is one of the last places where you do have this really, I think, kind of pretty good sense of collegiality across sort of political affiliations. You obviously have some lawyers that are rooting for the Democrats, some that are rooting for the Republicans, but some issues are cross-cutting. But also because it does sort of take two to argue a case, I think there's a lot of respect across the aisle, so to speak, for somebody who argues the other side of your case well. Even though they're arguing against you, and and the clients change and the issues change, so you tend to have an opportunity to work with people, on the other side. So, my sense is if you sort of think about, if you read about sort of the way the Senate operated and kind of, the good old days when there's a lot more sort of cooperation across the aisles, you still see that in the Supreme Court bar. So, I'm feel very privileged to be part of that.
Mm-hmm. Well, in constitutional language, I will thank you for experiencing this cruel and unusual punishment for the last 15 minutes. You've been a terrific guest, and I look forward to your talk tonight. The Center for Civic Leadership at Benedictine University in Lisle, Illinois, is welcoming Paul Clement, the 43rd Solicitor General to the United States, served from 2005 to 2008 for George W. Bush, and I must say has been a fantastic person to work with on this event, and I wish you the best in the future.